About 25 years, Kleber and I spent a few hours sitting in chairs with a table and drinks in front of us. It usually wasn't water, and we never had a video camera and a bunch of people looking on. But we'll see what we can do. John's comment about taking a ride on the Kleber bus. I had an opportunity to do that for many years, and to steal the line of a former partner of mine about his former partner. People asked what was it like to try cases with Kleber. I'd say kind of like it was trying cases against him. he would wear you out, beat you down, make you feel stupid, but it was always a heck of a learning experience to do it, and he was always a gentleman. But some things you may not know about Kleber, before he got his law license from the University of Texas, he helped get a rather distinguished politician elected down there and played a very instrumental role in a campaign. Kleber, tell us about that and who that was and what you did.
First, before I do that, let me say about the kind remarks that John and you have made. It reminds me about the lady whose husband died and she was at the funeral. And the preacher went on and on and on about what an outstanding man he was and all of his wonderful characteristics. After he'd been going on a few minutes, she leaned over to her little son and says, "Billy, run up there and look in that casket and make sure that's your daddy." As I listened to that, somebody better look in the casket. What R.H. is talking about is, when I was in law school, I decided that a lawyer ought to know a little bit about politics. And I was in school at the University of Texas and had grown up in Austin. And Lyndon Johnson was our congressman. And he was running for the Senate against Coke Stevenson. And he was conducting a campaign in a helicopter. And nobody had ever seen helicopters in those days. They were brand new. So I went over to Lyndon Johnson's office and volunteered to work and do whatever hauling wood and water and dirt the young law student can do for that campaign. And after working, and John Conley and Jake Pickle, two eminent politicians, were running his campaign. So they got desperate and they assigned me the job of driving a sound car. And my job was to go to the small towns in Texas, drive up and down the street with a loudspeaker on the top of my car and say, "Lyndon Johnson's coming in. He's going to land in a helicopter in Senator and Joe Jones's pasture out here east of town. If you haven't ever seen a helicopter, come out here and see a helicopter and meet Lyndon Johnson." So then, after doing that 2 or 3 times up and down the town square, I would go out to Farmer Jones's pasture, and Lyndon's helicopter would light, and there would be anywhere from 5 to 50 people there, and a big crowd, maybe 75. And Lyndon would get out and he would talk to those people over my sound system in my car. And then after he finished that, he would go down to see the editor and the mayor and the people downtown. And I would put my foot in the carburetor and go down the road 20 or 30 miles and say, "Lyndon Johnson's coming into town if you haven't seen a helicopter." So that was my giant role in electing Lyndon Johnson. He did get elected in the landslide election where the 17 votes came in from South Texas 2 or 3 weeks after the election. So I can't say that I had any real part in any of that. But as a young lawyer, I learned a lot watching those people work.
I always thought when I saw Lyndon Johnson on TV, he seemed so dry and uninspiring and not very charismatic. Was he like that out there talking to those 5 or 10 people?
He had the ability to talk to those folks and have them eaten out of his hand in a few minutes. He'd get off and he'd look out there and he'd say, "I see my Uncle Joe and my Aunt Molly and people just like the folks I grew up with." And I bet you can remember getting up in the morning and taking a potato off kerosene can and filling the lamps and getting the kids ready and going to school. And that's the way I grew up. And by the time he finished with those people, they thought he was part of their family, you know. He had a wonderful knack that never came across on television, but in a one-on-one with people, it was something to behold.
I'm assuming after law school, you graduated near the top of your class and went off to work for some big law firm in Houston or Dallas. Is that about the way it happened?
I barely got out of school.
Tell them about your first experiences in Austin practicing law.
Well, my first job, I went to work in the district attorney's office in Austin. And the district attorney, this is almost unbelievable, but there were 4 of us in the district attorney and 3 assistants in Austin. And we had so little business at that time that we could have a private office downtown where we could practice law on the side. So I talked this small firm into letting me come down and use one of their vacant offices and talk to their secretary and ask her occasionally if she would bother to type something up for me. And I sat there and looked out the window and wondered if I was ever going to have a client. And one day, a lady walked in my office, and a friend of mine had sent her over. And it turned out that she was a madam for one of the local houses in Austin. And she had a lot of money. And she had bought a piece of real estate, and she wanted me to examine the title. This was back when lawyers examined title, and close this real estate deal for her. So I told her what a great job I was going to do for her, and she left, and I got this abstract, and I looked at it, and I turned it this way, turned it that way, and I looked at it, and I wondered what in the heck I was supposed to do with it. And I thumbed through it, and when I got to the last page, I saw that the local bank had made a loan on this property. And I just happened to know the lawyer who represented the bank. So I hightailed it over to his office with hat in hand and went in and said, I've just been hired to examine an abstract and close this real estate deal, and I saw that the bank had made a loan, and I wondered if you knew anything about it. And he said, well, you're in luck. He said, I examined that abstract just about 3 months ago. And he said, here's my title opinion. Said if nothing else is in there after that, you can just copy that. So I did, and I closed that deal, and I swore an oath that I would never, ever have anything to do with an abstract again. And I didn't.
Can y'all hear okay? You made your way to Fort Worth, I guess, shortly after that. Who hired you? Where did you go to work in Fort Worth? Tell us a little bit about that.
I had a friend that I'd been in law school, young lawyer named Bill Sarsgaard. He and I were close friends, and he'd come to Fort Worth and gone to the firm of Crowley, Hudson, and Keltner here, and I was in the district attorney's office in Austin. And after several months, he called me one day and says, our firm has just inherited the Santa Fe Railroad account, and we're going to take over 100 trial files overnight. We desperately need somebody interested in doing trial work. Would you be interested in coming to Fort Worth? Well, I was born and raised in Austin, and so was my wife, and I was in love with Austin and the University of Texas, and I thought, well, I'm probably not going to do that, but I'll go up and talk to them. So I came up and visited with them, and they were a nice bunch. And I went and told them I didn't much think I was interested in leaving Austin. Went back home and tossed and turned for about 3 nights, and every night I'd think, that's a real opportunity. I'm here in the DA's office, not getting anything done. So I called them back and I said, is that still open? They said, yeah, and I said, well, I'll be there. So I showed up January the 2nd on 1952 and went to work in Fort Worth, and it's been a wonderful ride ever since.
For those who may not know, Keltner was Mr. Ed Keltner, who was David Keltner's dad, right?
That's correct.
And Crowley was who?
Alan Crowley, who was president of the state bar and a very fine trial lawyer, my mentor and close friend and somebody, and he was George Crowley's father, Judge George Crowley's father, Alan Crowley.
Well, tell us what that litigation practice was like back then.
Well, Al did mostly insurance defense work, and Luther Hudson represented the Santa Fe Railroad. I worked mostly with Al Crowley, so I did mostly insurance defense work. And the great bulk of the work was workers' compensation, slip and fall, little automobile accident cases. The average time that we had a file open was about 4 or 5 months. In every case, you'd take generally one deposition, and that would take you about 45 minutes. You'd go to the courthouse, go to trial with a file that looked about like that. And when you got through, whoever was in charge of it would say, well, we ought to charge about this much money for that case. There was no such thing as timekeeping or rates or anything else. It was just your feel on what you ought to charge for that case. So it was a practice that was so foreign to what goes on today that it's almost unbelievable.
What kind of money were you making back then? What was your starting salary? Do you remember?
I remember very distinctly. They paid me $200 a month and all the drinking water I needed. I was so proud of that. I took my first month's paycheck over to the Fort Worth National Bank to deposit it and laid it down with a deposit slip, and the teller looked at me and said, what do they do, pay y'all by the week over there? But at that time, you weren't looking for benefits, you were looking for a job.
How often did you go to trial back then? Kleber? Every week or so?
Well, and as it developed, Al Crowley and Luther Hudson had a disagreement 2 years after I went to work for the firm. And so they split up and they recruited young lawyers to go with them. So I ended up being offered a partnership 2 years after I started practicing law, just because I just happened to be in the right place at the right time. So I went with Al Crowley, whose work I did. And as a result, I immediately inherited a lot of files that ordinarily I would not have handled. But I generally carried anywhere from 200 to 250 trial files. Most of them were routine insurance defense cases. I would have cases set in 6 to 8 counties every Monday morning. In those days, the plaintiffs' lawyers were setting every case in their office every time they could set it, and so you ended up having 20 or 30 cases set every month, and you didn't know where you were going to be next Monday or where you were going to go to trial. You'd get called Tuesday morning for number 26 case on somebody's docket, and it was a real juggling act, and you learned how to be a trial lawyer. I probably picked a jury, I'd say 2 weeks out of most months of the year. Frequently, the cases would settle somewhere during the trial, and a lot of those wouldn't go through to a verdict. But you were in court constantly, and you learned how to try a case, and you learned how to be comfortable in court because you were there so much.
Well, some of my unfondest memories of being in trial with you for 6 and 8 weeks in some cases. How does what you do today compare to that kind of litigation, and what's better about it and what's not so much better, maybe worse about it than back in those days, the practice of litigation in general?
Well, there's really no comparison. Back in those days, I did insurance defense work, and so the insurance companies would bring me a file, and the insurance adjuster would have worked that file up, and there would be a statement from the witnesses, and there would be a report from the doctor. That was usually personal injury cases, and you could go up there and try the case from your file. You didn't have to do a lot. The plaintiff's lawyers, on the other hand, they had to work their cases up. But from the kind of case I was trying, I would go to trial with a 45-minute deposition of the plaintiff. There was no such thing as the kind of discovery that goes on in lawsuits today. If you wanted to know something about the other case, you generally picked up the phone and called the other lawyer and said, would you send me so-and-so records, or would you send, what's your view on this? And the lawyers got along. The lawyers worked together, and the lawyers didn't play footsie with each other and didn't try to trick each other, and it was much more on a professional basis as far as trying to work things out agreeably than it is today. As I said, you'd go up and you didn't need to prepare your cases in as much detail. I can remember going to trial and one time, and Dave Ballou, who later became the federal judge here, Judge Dave Ballou, and I were co-defendants. And he walked in the courtroom and looked around and said, "Kleber, which one is my client?" And that's just the way it was in those days. And you learned to try a case off the seat of your pants. You'd read your file and figure out what it was about while the other lawyer was examining the jury. But today preparation is key to being a successful trial lawyer. Cases have gotten more complicated. The discovery rules have come along. Court activity has gotten to be 10 times what it ever was back in the old days. Cases are much more technical. They're harder fought. You fuss over details that you used to not fuss over. And you go to court with 3 people carrying 2 file cabinets full of records and stack them up in the courtroom, and you have to have 2 paralegals helping you and somebody like me who hadn't kept up with technology to run your computer for you and be sure that you don't stumble on it. So it's such a monumental change that it's hard to describe. Now, if you go to trial, you go to trial for weeks. And maybe if you go to trial once every year or 2 years, that's a pretty heavy trial docket compared to the old days when we were in court constantly. So the opportunity today for a young lawyer to learn how to try cases like I learned how to try cases just is non-existent today.
Well, what can a young lawyer do these days, do you think, to help try to develop trial skills given the environment that they're in?
I wish I knew the answer to that. I think that's an answer. I think that's the answer that the bar and the trial bar is grappling with. How do lawyers learn to try cases today? Because I don't think there's any real substitute for experience. Until you try enough cases where you walk in the courtroom and you're worrying about the facts of your case rather than where do I sit and what do I do and is it time to make an opening statement and that sort of thing. Unless you try enough of cases that all of that becomes second nature and just reflective action, well, you never will be a proper jury trial lawyer. And how you do that, I know some firms try to have trial programs. There are organizations that have trial schools. But I think there's no substitute for experience. And if I were a young lawyer, I'd take on anything I could that would get me in the courtroom, even if I lost a little money on it, because that's the way to learn how to try a lawsuit, is to go in there and get your feet wet and try it. And I really don't know any substitute for that. Wish I did.
Well, one of the things that I always was awed by is, and I guess every trial lawyer wants to be a great cross-examiner, but I was always amazed at how you could do a cross-examination and very quietly and effectively make points that I thought, man, I could have never done that. Is there anything in particular, any magic tips for young lawyers in developing skills to develop cross-examination, you think?
Well, in the first place, I think you're wrong. I think you're a lot better cross-examiner than I was. But as far as cross-examiners, as far as practice of law is concerned, I firmly believe that the practice of law is an art and not a science. And that you take 5 lawyers and they're going to approach the same problem 5 different ways. And that every lawyer develops his skills in his own way and according to his own personality and with his own approach to things. You can see good trial lawyers, and you'll see different personalities, you'll see different approaches, you'll see some that are bombastic, you'll see some that are quiet, and I've tried to decide what's the common thread that runs through a good trial lawyer. What makes a good trial lawyer? And I believe it's the ability to communicate. And by that, I don't mean just talking. I think you communicate by the way you act, by your conduct, by the way you present your case, by the way that you build a story to tell in the courtroom for the jury. But all good lawyers have the ability to communicate to the jury what they're trying to get over. And when it comes time to just cross-examination, I think the key is to determine what you want to accomplish in your cross-examination. You need to know what you're trying to do before you ever start. Are you trying to bring out certain salient facts from that witness? Are you trying to impeach him on things he said that you can impeach him on? Are you trying to confuse him? Whatever your goal is, you need to have a goal. And depending on what their goal is, your cross-examination will be different. I think the cardinal mistake that lawyers make is that they think they have to cross-examine. And you don't have to cross-examine. Sometimes the best thing you can do is just pass the witness. And the second cardinal mistake I think that I see people make in cross-examination is giving the witness a chance to tell the story again that hurts you. Somehow lawyers tend to think, I've got to ask him again what he said. And I don't believe you ever ought to do that unless it's so rhetorical and you think he is so ridiculous in what he says that you're trying to make the point, so you get him to state that again and again to show how ridiculous it is. Other than that, you need not to give him a chance to say the things again that are going to hurt you. And I think that one of the goals of every cross-examiner ought to be, if he can, to make that witness your witness. Find something that he can say that helps your case. Make him your witness if you can, and ignore the things that he says that's on the other side. All of that's easy to say. You hear all these rules about cross-examination. Every one of them has exceptions, and you just got to decide, what is it I want to do? How can I best do it with this witness?
Are there any in your well over 50 years of practice now, is there any one or more cases, litigation that you've been involved in that sticks out as being particularly interesting, fun, important over those period of time that you can comment on now?
I've had so many interesting cases that we'd be here the rest of the night if I talked about them. And I don't know how much time we have on this question, but the wonderful thing about the practice of law to me is the variety that a lawyer has to deal with. You don't get in a rut. You see so many different things. And just as kind of an example of the variety of the kinds of cases that I've tried that kind of stick out to me is cases that I remember distinctly. I remember one case where the state of Tennessee liquidator took over an insolvent insurance company, entered a judgment in Tennessee enjoining anyone from interfering with the funds of that insurance company. I represented a local bank, and the local bank had some funds of that insurance company on deposit with the bank. I filed an interpleader action, and the state court in the state of Tennessee objected to that, saying that was interfering with their jurisdiction and their judgment in Tennessee. We tried that case. It was appealed to the appellate court and to the Supreme Court, and the Supreme Court ultimately held that that interpleader was proper. The state of Tennessee then turned around and sued the bank I represented in the federal court, claiming that the bank had violated their injunction and that the bank should be liable to the state of Tennessee for the monies that had been taken out of the account. That case was tried in the federal court, and the Fifth Circuit upheld our position that the state of Tennessee did not have jurisdiction over a local bank in Texas, and that the doctrine of laches and estoppel and other theories that they pursued had no bearing. That was a complicated mess that took over a long time, fussing with the state of Tennessee that would send teams down here to take on that litigation. Another case that I remember, I represented Mr. O.P. Leonard, and he brought a judgment that had been entered in 1919. The Delta County Levy Improvement District. Delta County is up north of Paris, smallest county in Texas. And they had created a levee improvement district and sold some bonds to build a dam on the South Sulphur River. The contractor had absconded with all the money, and the dam never got built, and so the levee improvement district never paid off the bondholder. They took a judgment against them, and it had been kept alive by issuing execution every 10 years. Only the law is that you can't execute against a government entity, so that execution would be returned nulla bona every time. Well, Mr. Leonard bought those judgments for a song, and he shopped them around to several big law firms, and they told him he didn't have a chance, they were way too old. This was 40 years later. And he brought them to me, and I looked at them, and I said, I think maybe we got a shot, Mr. Leonard. So we filed suit up in Delta County and went up there, and the judge required us to have a jury trial on the issue of laches and estoppel and waiver and that sort of thing. So I was faced with the prospect of convincing the Delta County jury that they ought to tax themselves to pay these judgments that had been drawing interest for 40 years. So as you can imagine, they poured me out in about 15 minutes. We appealed it to the Texarkana Court of Appeals, and they reversed, saying that those judgments were still alive and that it was proper to bring suit. I had brought a writ of mandamus to require the levee improvement district to levy taxes to pay off the judgment. So they then sued us again in Delta County, and we went back up a second time and had another trial over whether the taxing authority could levy taxes to pay off those judgments. I promptly lost that case in Delta County. That was appealed to the Court of Appeals, and it was reversed, and subsequently the Supreme Court said that it was proper to bring a writ of mandamus, that the judgments were still alive, and that even though you couldn't collect from a county or a levee improvement district by execution, that was a proper way to keep the judgments alive, and the judgments were still valid. They tried to get in the United States Supreme Court on that, and the United States Supreme Court refused the writ. So that was another interesting scenario. The third one I'll mention is I represented an independent oil operator in Midland, and we sued Valero Oil and Gas Transmission Company. They had a long-term gas purchase contract with for high-priced gas, and this was in the 80s when the gas bubble came along and gas prices nosedived. And Valero took the position, we can't take your gas under this high-price contract, but we have a subsidiary of ours who can buy that gas at cheap prices and sell it on the spot market. Well, I brought a suit against them saying that they were tortiously using their corporate structure to violate the rules of rateable taking of the Railroad Commission. Tried that in Midland, and we got a $6 million judgment from the jury out there. They appealed it to the Court of Appeals, and the Court of Appeals and the Supreme Court upheld that as being an improper use of corporate subsidiaries to violate the Railroad Commission rules. So those are just three examples of three widely varied cases that make it such a pleasure to practice law and get exposed to so many different things that you would never be exposed to in the ordinary course of events. Now, there's some others that are kind of funny, but I don't know whether we have time to talk about them or not.
I was going to say, I've heard some other cases that Kleber talks about, but he chose not to talk about those right here in this setting. But like he said, he could go from now on and you'd never get tired of listening to those types of cases. One thing that if you've ever gone against Kleber, or if you ever have to in the future, and these stories represent, is he never gives up. He will never give up until the last straw and the last thing has been tried. Kleber, I remember one time, I had only been at Shannon Gracie, I think a couple of months, and it was back when the firm recruited young law students to come in and interview them for summer associates. And they were having a reception up in the big conference room there, and there was this little gaggle of law school students around Kleber, and one of them said, Mr. Miller, what type of litigation do you like best? And you remember what your answer was?
I really don't. I probably said those where the client can pay the fees.
That was his answer. His answer was paying litigation. Well, of course, he had a drink in his hand, and he got this distant look in his eye, and talked about all these cases, and said, after all that, I've decided the kind of litigation I like best is paying litigation. And of course, these young law students kind of looked like, what's he talking about? Well, I think our time is about up, Kleber. We would be remiss, though, if we didn't do one thing here as a group, I think. And that is, 2 or 3 weeks ago, Kleber had a birthday. And I think we would be remiss if we didn't raise our glasses and give Kleber a happy 90th birthday that he recently celebrated.
Thank you. Thank you.
All right. Would you like to make any closing remarks?
About what? I would just say that I can't tell you how much I've enjoyed being a lawyer, and how proud I am to have been a lawyer. I think that today there's a great danger of losing professionalism in the legal profession. We talk about delivering legal services, and we get so wound up with the holy billable hour that somehow we forget that we're professionals. We don't deliver a block of ice. We don't sell a bag full of wheels. We deliver a professional service. And as professionals, we ought to remember that clients have disputes. Lawyers should. And I hope that as the legal profession goes on, it will never lose its pride in its professionalism. And it will never lose sight of the fact that it is a service industry rendering service to its clients. So that's my final comment.